Fernando Garcia versus Simply Home Realty.
This case is about whether the money taken from my security deposit was fair under Washington law. I am not arguing about timing. My issue is that most of the charges were for normal wear and tear and regular turnover cleaning. The landlord charged for things like scuffs on walls, small marks from stickers, pet hair on baseboards, and general cleaning. These are normal after someone lives in a home and are part of preparing the next tenant. I received a check for $377, but I never cashed it. I tried to settle this before court, but we cannot come to an agreement. I'm asking the court to decide what deductions, if any, are fair, or to order the return of the rest of my deposit. Thank you.
Okay. And who would like to speak for Simply Home?
We feel like the charges are accurate and legal, based on, we uploaded a couple hundred photos as proof. The home was freshly painted, just a few days before the tenant moved in a year prior to vacating. Let's see. So we feel like, if there had been a couple spots here and there in the home for the walls marked up, we wouldn't have charged them. That would be normal wear. It's every room throughout the house. There's a lot of dark areas and scuffs and dirty, and it was just excessive amounts to be calling it normal wear for just being painted a year previous.
And am I right that the security deposit was $4,312.50?
Yes.
Okay. There was the charges for painting, carpet cleaning, landscaping, anything else?
Yep, there was repairs, cleaning, landscaping, and the carpet was only the enzyme treatment for the pet, not the actual carpet cleaning.
What do you mean by that? The enzyme cleaning, it's not, you don't consider that carpet cleaning?
So the owner pays for the carpet cleaning according to the law. And the enzyme treatment, it is an additional charge. And a tenant that has a pet is charged just the enzyme treatment fee, not the actual cleaning. The exhibit 13 on ours is the carpet cleaning invoice.
Which exhibit? I guess I should ask Mr. Garcia, which is the exhibit that's the lease? Or did you provide the lease?
The lease agreement was, I believe, I'm looking for it, I'm sorry. I don't think I uploaded the lease agreement, Your Honor.
Did you include the lease agreement, Ms. Olsen?
We did. It's the exhibit 1 on the first page.
There it is. I did review, to be clear, I did review all of the files for all of my cases today.
Okay.
But after the exhibit numbers kind of blur together.
Oh, I'm sorry.
Take this to mean that I did not review where in the lease does it say that the enzyme cleaning is to be deducted? Can you point me to that, please?
Yeah, just 1 second. I think that's actually going to be in the pet addendum. Sorry, not the lease. We have a separate document for the pets. Okay, so paragraph 4 in the pet addendum for cleaning.
Looking for the pet addendum.
Oh,
Where is the pet addendum?
Okay, it's not letting me load this beyond the first page, I'm sorry. It's going back to a blank.
I see an exhibit A for tenant charges. Exhibit B, move out cleaning checklist. Exhibit C is an insurance addendum. Exhibit D is a smoking policy addendum.
So there's an extra uploaded exhibit for the pet addendum, I'm sorry. That's what I was trying to find for you, where it's at on the list. And it's going
There
back
it
to
is.
the main blank
Pet
page.
addendum. There it is. Okay.
Oh.
Can you point to me where in the pet addendum it says, let's see, cleaning?
Yeah,
So that's the
paragraph
thing, I
4.
don't see it. Apology, what's that?
Paragraph 4 is for the cleaning. And then there's also in our move out cleaning checklist, in the lease, it does also say that if animals were present on the premises, the tenant will be charged for enzyme treatment at the time of professional carpet cleaning.
Mr. Did you have anything else you wanted to say?
Yes,
Ms.
when it comes to
Olsen?
the enzyme treatment,
Oh,
enzyme.
I was asking Ms. Olsen real quick. Don't worry, I'll get back to you.
Yes, Your Honor.
Just remember what you wanted to say and you'll have a chance to enter what's called a rebuttal.
Yes, Your Honor.
Okay. Anything else from you, Ms. Olsen?
I don't think so. We're just kind of disappointed in, to see the condition of the home after only being there for a year.
I'm sorry, was it Kian or Kian?
Kian.
Kian, okay.
Mr.
Mr. Kian, anything from you?
Well, we tried to discuss it with Mr. Garcia. We scheduled a Zoom meeting with him earlier this week, actually last week. Oh, maybe this week. And we tried to explain and reason with him and address his concerns. We spent more than an hour in the conversation, and we showed him the proof, and we uploaded all the proof to the court files. It's the claims are outrageous, honestly, because the condition of the house, if you go through the pictures, you will see that it does not qualify as normal wear and tear. We've been doing property management for 10 years. We've seen multiple houses, and after a 1-year stay, that's a pretty bad condition to see. We just hope that you will see the evidence and you will make the decision based on what you see in the file and based on the documents we have.
Just taking a final look at the pictures again to refresh my recollection. Great job. Just switching out clerks here.
Your Honor, and if I may add, it looks like most of the charges and most of the concerns that Mr. Garcia has are related to the painting or condition of the walls in the property. And I just found in our records that the painting was done 3 days. The full painting of the full interior painting was done just 3 days before they moved in a year ago. So it was a brand new painting inside. And if you look at the marks and if you look at the smears and everything that was left apparently by the animal, by the pet or animal in the house, maybe by the kids as well, it's excessive, extremely excessive. And that's why we had to do a lot of painting to cover and bring the house to the move-in standard.
Seen the pictures of the walls. I'm looking for pictures of the yard, which I'm trying to remember.
I wrote down a couple of the numbers for you just so you can look up a couple examples easier because I know there's a lot of photos. 2024-9-27 11 17 27 was a move-in photo from the backyard. And then I have a similar photo from move out as well. 2025 9-23 12 14 49. Can show that there was, you know, some tall weeds growing and the sides of the yard were growing up on the fence and needed to be weed eated. The grass was very long and it was saturated from a leaking broken sprinkler that we didn't know about. We weren't told about it. So and then the bushes in the front by the porch. There's 2024 9-27 10-30 13 was one from move-in. And then 2025 9-23 14 15 26. It kind of shows how the bushes are kind of growing around the pillar and stuff. They weren't trimmed back and maintained.
Okay.
Yeah, I just
And I just want to take another look at the breakdown of the costs. Can you remind me of where that is?
the cost.
For each charge.
Okay. So for all the invoices should be uploaded from both of us. Let me see. Like I said, I can't get off of that main page for some reason.
There's a blue arrow at the top if you're looking at one that looks like mine. Are they?
I'm logged in looking at the exhibit list. When I try to go to the second page, it just goes back to the blank search page. I can't go beyond that for some reason.
Usually down at the bottom, if you kind of scroll down the listing of, a lot like the list of the files, I think down at the bottom, there should be additional pages available.
Yeah, and when I go to the next page, I just get the blank black page to search for it again. I'm not sure. Nothing's coming up. I don't know why it's doing that.
It's okay. I found it in, I think.
I know the carpet cleaning invoice and the cleaning invoice are on the first page because I can see those.
And were those provided within 30 days?
Yes, they were mailed with the settlement statement and the refund check.
I'm ready to rule. Unless, oh, excuse me, Mr. Garcia, you had something you wanted to say.
Yes, ma'am. So like when it comes to the walls and the paint, when we spoke during the settlement meeting, they said that they were like had to do touch-ups, which touch-ups are painting a standard turnover, not tenant caused damage. When it comes to the enzyme treatment, that's preventative and not a repair. So that's also not tenant caused damage. And when it comes to Washington, the lease language cannot override the Washington law for or Fair Housing on Act ESA protections because the animal is a support animal. Yeah, I just wanted to bring those things up. And that there were scuffs in many rooms, but normal wear and tear can happen throughout the home. Doesn't just have to be in one specific spot. And a lot of the in the pictures, there's like you could tell that it's like kind of like wiped. It's from us trying to clean some of the scuffs. And yeah, we tried our best when it came to like cleaning the home, and we spent several days cleaning it before turning over the keys, Your Honor.
Look at this pet addendum one more time.
So I was incorrect earlier. It does actually specifically say enzyme treatment in our lease agreement in the move out cleaning list. I'm sorry. And that,
Can you point me to what page?
it is page 12. I have to disagree on the cleaning marks on the walls. They're dark black smears. When you wash a wall, the paint will fade. It doesn't get darker. And I just wanted to say that.
All right, let me go back to the right page that I had up here, and then we'll move forward. Thank you. Oh, where did it go? I want the breakdown. Too many open. Yeah, I'm having some. I don't want these. I had it all set the way I wanted to, and then it changed. Here. Thank you for your patience. I am, here we go, as a pro tem, it can be working with the technology can be the hardest part. Okay. So when preparing for this case, I did look at the information provided by both parties. I looked at all of the photos. I also reviewed Washington law with regards to landlord tenant. And particularly, I reviewed RCW 59-18-280, which states that no portion of any deposit may be withheld for wear resulting from ordinary use of the premises for a carpet cleaning, unless the landlord documents wear to the carpet that is beyond wear resulting from any ordinary use of the premises. For costs of repair and replacement of fixtures, equipment, appliances, and furnishings if their condition was not reasonably documented in the written checklist required under RCW 59-18-260. And so when we're thinking about this, I'm going to turn to the move out settlement statement with regards to what my ruling will be. I will while I do believe that there were a lot of scuffs on the wall, in my view, those were still within what I would constitute to be normal wear and tear. I do understand that it was perhaps greater than what you may have seen in the past, but as I did research into what constitutes normal wear and tear, it does not appear that this would go beyond what is normal wear and tear. It also did appear to me from the photos that the premises were reasonably cleaned, and there is, excuse me. and that the types of cleaning that may have needed to have been done were within normal turnover. When we rent premises out, there is some work that needs to be done between tenants. I also note that under RCW 59, so I will not be ordering, I believe under general maintenance, $2,616.42, the turnover repairs and the cleaning, turnover cleaning, $822.75. That does not appear to be appropriate charges to me. With regards to the carpet cleaning, there is within, you were able to point me to where you were in the lease. It stated that enzyme cleaning would be required of the carpets, but I do note that in RCW 59-18-280, it states that that no portion of the deposit may be withheld for carpet cleaning unless the landlord documents wear to the carpet that is beyond wear resulting from ordinary use of the premises. And it appears to me that within your lease, this is a standard clause that you are including requiring carpet enzyme treatment when there are pets. And it appears to me from my legal research that tenants, although tenants are free to enter into leases that include certain lease terms, the tenants may not sign away their rights. And the specific language in RCW 59-18-280 states that charges for carpet cleaning may not be assessed unless it is wear to the carpet beyond wear resulting from ordinary use of the premises. I therefore find that carpet cleaning in the amount of $84.32 for the enzyme cleaning was not appropriate. With regards to the landscaping charges of $411.38, I do note that the lease does state that the landscaping is to be maintained by the tenant. And I have reviewed the photos for what needed to be done to the and it appears that the tenant would need to pay for some of that. However, $411.38 seems excessive to me based on my experience with gardeners and with landscaping, but I will order that half of that be paid. With that, I will fine for the plaintiff in the amount of everything except for half of $411.38.
Your Honor, are we allowed to ask questions?
At this point, you may.
Well, we are a little bit confused with the ruling because we show excessive smears on the walls, which are definitely, in our view, in our understanding, which do not qualify as normal wear and tear. Because in this case, we're looking at many hours of work that had to be done to bring the property back to the condition, to the rentable condition. And if the tenant is not paying that, it looks like the owner will have to pay the bill, the repair and maintenance bill. How can we justify that such excessive repair, such excessive time that was spent on the property can be considered as normal wear and tear? If you allow us to share the screen, to show the pictures specifically, I'm not sure if there was any technology issues.
Perhaps you were not here earlier for my speech in which I indicated that oftentimes when we go to a hearing, one of the parties is going to be disappointed. And I was not there. I had to go based on the evidence that was put forth before me, which was the photos. And the photos to me did not look that bad. I understand, and I hope you understand that I was not there. I did not do a walkthrough. I did not see it with my own eyes. And this was information that I did cover at the very beginning of this calendar when I stated that it is very likely that one of the parties will be disappointed because I was not there. I could not see what it was. And if anything, when I initially reviewed this file, it seemed to me that the types of charges that were being made were not reasonable. And after this hearing, I continue to feel that way. And that is my ruling and my judgment based on what I have seen, the testimony that I have heard. And that is my judgment. And I understand that you are disappointed. That is the nature of hearings, as opposed to reaching settlements, which is that one of the parties will be disappointed. In this instance, with regards to, I did do my best. The question of what is normal wear and tear is something that has interested me for quite some time. But I think that based on the photos that I have seen, that this is the just and legally correct result.
Your Honor,
Mr. Garcia. Mr. Garcia, can you remind me of what the total amount was that needed to be returned?
so for landscaping, they charged me $411.38, which you said would be a half. The carpet cleaning was $84.32.
So real quick, so I'm looking at the settlement statement. It looks like the total deductions were $3,934.87.
Yes.
And then I stated that part of that landscaping was appropriate. So I'm going to go 3934.87 minus 205.69. So I'm going to order a refund of $3,729.18. That is my ruling.
Your
And
Honor,
I'm
when
receive
it
a
comes
copy
to
of
the
this.
check of the $377, I just throw that away, like rip it up and just.
What I would do is I would write void on it and mail it back to the company.
Yes, Your Honor.
Or wait, let me look at this math here. Because you were refunded, the deductions were $3,934.87. And then they refunded you the $377, which you are allowed to keep because my ruling was that they overcharged you. So I take that back. You can cash that check and they owe you another check
Yes,
in the
Your Honor.
amount of $3,729.18. Okay. With that, you are free to go. You'll be able to get a copy of this judgment by Monday.
Thank you,
Thank
Your
you very
Honor.
much.